Okay, everyone. Chairman Mulvaney is celebrating the birth of his daughter, who turns 25 today. So he is not making it. So I will be running the show. Oh, and look, now he's texting me as soon as we start. Okay, so to begin, everyone, welcome. This is a Planning and Zoning Commission meeting. Today is Tuesday, June 3rd, 2025. It is 7:03, and we are in room 206 in Town Hall. Tonight we have a public hearing and a general meeting. So let's dive right into the public hearing. So the first item on the agenda tonight is the proposed amendments to the Darien Zoning Regulations, COZR number 2-2025, PL 2576, put forth by the Town of Darien Planning and Zoning Commission. This is the proposal to amend the Darien Zoning Regulations to specifically define smoke shops, vape shops, and tattoo parlors, and to create a new section 1135 of the zoning regulations to specifically prohibit those uses. Other amendments are to make consistent reference to the Town Plan of Conservation and Development, and to specifically refer to the newest version of the state CT Deep Soil Erosion and Sediment Control document in section 873, and the Town of Darien Stormwater Management Manual in section 880. The full text of the proposed amendments are on file and available at the Town Clerk's office and the Planning and Zoning office for inspection, and online at darienctviewpointcloud.com as PL 2576. Guys, what do we got?
Sure. Welcome. As you noted, there are 5 separate zoning regulation amendments being put forth. The first 2 are somewhat related in terms of defining vape shops and smoke shops and prohibiting them. And then there's 3 others which are separate topics. But for convenience, I wanted to start with the final proposal, if you will, regarding the Stormwater Management Manual and referencing that. And the reason for that is our consultant, Joe Canis of Ty and Bond, is here tonight. He worked very hard with Ed Gentile and Darren Ostafine over in Public Works on preparing the new manual, which is an update of the manual from 2003. So I wanted Joe to give a quick presentation, tell you a little bit about some of the changes that are forthcoming, and then we'll talk a little bit about some of the other topics. But I figured while Joe is here, I can give you a little quick PowerPoint. Joe, come on up. I do want to say that while Joe was developing this, we did reach out to numerous engineers who do work in Darien, who you've seen, about 10 or 12 different engineering firms, 30 different engineers. We gave a presentation, asked them to comment. Joe incorporated comments where he could, or gave further explanation, or better explained something in the document. So the goal tonight is to explain some of these changes, and then we'll talk about how the commission can then reference that document.
Okay, thanks, Jeremy. And for the record, my name is Joseph Canis. I'm a licensed professional engineer in the state of Connecticut. I'm a principal engineer with Ty and Bond in our Shelton office. And we were retained by the Planning and Zoning Department for the update to the existing Stormwater Management Manual. Before I start, I'd like to also extend my thanks and gratitude to Jeremy, Fred, Hervé, Rick Talamelli, as well as Ed Gentile and Darren Ostafine for their assistance in putting this together. It was not a light lift by any means, but so I'll give you an overview of what we're proposing. Now, as you well know, the Town of Darien does have its own Stormwater Management Manual, which was last updated in 2003. So a lot of things have changed then. Like my daughter was born in 2003. She graduated from college 2 weeks ago. So it's been a while. Right, so we already went over, basically it's, old. It also predates the development of the zoning regulations, section 880, the stormwater management regulations. In your zoning regulations, this manual is actually older than that. And then the state has also issued 2 of their own stormwater quality manuals since 2003. So we're a couple generations behind with the existing manual as it is right now. And as you know, in the past 22 years, stormwater management has evolved, right? We look at things differently. There's, the concept of directly connected impervious area, right? How we treat runoff is different. The need for infiltration is different. Even the water quality storm has changed, right? It used to be that infiltrating the first inch of runoff was sufficient, or first inch of rainfall, I should say. But now it's because of the way precipitation patterns have changed, it's up to 1.3 inches. So that has also changed, and that'll be captured in the new manual. And the other thing is, as you all know, I've done a lot of technical reviews for the town. Both Ed and Darren have done technical reviews. And what we found in our reviews is that there are a lot of themes that kept coming up over and over again. And we're trying to address those as part of the new manual also. So what's new? The 2003 manual was more focused on, kind of like municipal development. It was less site development oriented. So we changed that. This new manual is very much more focused on residential development because that's most of the development that you are permitting through your regulations. We also brought it into alignment with the state stormwater quality manual. Like I said, that's water quality storm, which was 1 inch, is now 1.3 inches, so that's incorporated in there. We also provided some additional guidance with respect to swimming pools and patios, and I'll get into that in a little bit. We also provided some guidance with respect to basements and some pump discharges because we know that's a big concern of both not only this commission but also the Environmental Protection Commission. We also added standard certification language and formats so that no matter what project it is, the certification language is the same. You're certifying basically the same things, and there is now a form for that. And it also requires the use of the latest precipitation data. The 2003 manual actually relied on precipitation data from the 1970s. Although since then, most consultants have been using the updated NOAA Atlas 14, which is the current precipitation data, but we just want to make sure that it's codified somewhere. So one of the principal changes that we looked at was, one is a stormwater management report really required. And there are two things that really drive stormwater management in terms of impact. One is impervious area. The bigger your parking lot, the more area that you're paving, the more runoff that you get. The other is also land disturbance, right? Because it has a tendency to change how runoff patterns occur. So what we did was, and you can see the flow chart up here. I won't get into a whole lot of detail, but essentially under the regulations right now, the threshold for a full stormwater management report is 1,000 square feet. And what we found in looking at other municipalities, the threshold those municipalities have is lower. It's 400 square feet. And so this manual takes that threshold and moves it down to 400 square feet. And that's cumulative. Once you trip that 400 threshold, you have to prepare a stormwater management report. For example, Stamford, Greenwich, and Trumbull, they already have the 400 square foot requirement.
So when you say that's cumulative, it's kind of like they've made an application to expand a patio, and then 5 years later they've made an application to add an addition. There's a look-back period?
There's a look-back period of 10 years, I believe.
10 years.
I believe it's 10 years. Right, so any further questions on that? Okay, so I'll move on to swimming pools. And what we found is that a lot of times what we'll see in plans are swimming pools that just sit in the middle of the backyard with just coping and no patio around it. And that there's a couple reasons when we looked at this, because when you really think about it, more often than not in the department's experience is that these homeowners come back for a permit to build a patio, or they do one without filing for a permit. So what we've done for the purposes of trying to account for the proper sizing of the system at the time it's installed is to assume an impervious patio area around the pool. So basically, and I have a diagram on the next page, but essentially where patios are not proposed are comically small relative to the pool, the storm drainage system should be designed to a certain minimum patio width. And we went back and forth, this is one of the things that the group of engineers I presented to had commented on. So what you see in the diagram here, you have your typical 20 by 40 pool, and then it has no patio around it. Your hydraulic hydrologic computations would have to account for a minimum of a 6-foot wide patio around the pool. Initially, we had that number at 10, but in discussions, we dialed it back to 6, which seemed more realistic. You can take credit for existing impervious area that's within that 6-foot envelope. And this is just one of many diagrams that I have. There are others that show kind of different types of situations. But this is the general concept that we're proposing to do. The other issue that we addressed is how do you actually model the pool? You know, we've seen it done differently. We've seen some cases where people account for the amount of freeboard in the pool, right? Because you have a certain volume that's not taken up before you get to the coping, and we'll use that as storage, which is fine if the pool's open all year. But in the winter, you're typically covered, as you see in that picture there. So that's essentially runoff. So all pools get modeled in the new manual as impervious surfaces, right? So you don't get the credit for that, the amount of freeboard. The other thing, another thing that we addressed are basements. We've seen a lot of cases, as you know, in Darien, there are the soils aren't great. A lot of places have high groundwater. And when you install a very deep basement, what happens is you're into groundwater and you're constantly pumping groundwater right out on the surface, which exacerbates flooding issues downstream. So the manual goes through a multi-step process that encourages avoidance. So look at things like, can you raise the house? Can you reduce the height of the basement? Things like that. There's a flow chart, which I believe is on the next slide. That really works to discourage that. But the bottom line is, if you still have a deep basement, what you need to do is make sure that whatever you're pumping out of the ground, you put it back in the ground somewhere else on your property, is really what the bottom line of this is. I apologize, I don't have that flow chart, but the goal being not send the pump discharge over land, right, trying to get it back on the ground. That said, there are certain exceptions in there. For example, if you have a house that already has a sump pump, that's an existing condition, and you need to replace the pump, that would be okay. Another exemption is if you're discharging to the sanitary sewer, obviously you want that disconnected. And so there is an exception in there for that. Precipitation depth and distribution. Like I said earlier, the precipitation depths from the 2003 manual are outdated, right? So we require the use of the new Atlas 14, and I think nearly all, if not all the typical consultants the town sees do use the new data. But there's also a new distribution that NOAA put out a couple years ago. And to align with the state manual, we're also requiring that as well. And as you can see, precipitation depths have been rising in Fairfield County as a slow, steady march upward. And for climate change, we don't have any specific requirements. We do encourage applicants to look at it as part of their design, but there's no requirement to look at it. But there are several safeguards that are already built into your regulations. Like, for example, the fresh meadow approach, we can't take credit for existing impervious cover. And the requirement that your design infiltration rate, you only take half of that for the purpose of your design. So there's already there are some layers of conservative design built in there. Just for reference, the state of Connecticut uses 20 inches of sea level rise by mid-century. And if an applicant, for whatever reason, wanted to model the impacts of increasing precipitation, that NOAA Atlas 14 has data that actually reports confidence intervals in the precipitation for a given storm event, frequency and return period. So they could use the higher end of that estimate. Typically we use the median. Another thing is inlet connections in series. Basically meaning catch basins. You have one catch basin connected to another. Some projects, I just see an endless string of catch basins connected together. And the problem with that is It leads to resuspension of sediment in the sumps, because you got the water that's flowing through each successive catch basin, and it's churning up the debris within the catch basin. So what we did was we're trying to minimize that resuspension of sediment. So we limited that to 2 inlets connected in series. So basically you can go catch basin to catch basin, but then you have to go to like a junction box or something with a solid cover on it. And just for reference, this policy is actually a little bit more lenient than Stamford, where Stamford doesn't allow inlets to be connected together. So each inlet has to go to its own manhole or junction box. And this is just an illustration of what that would look like. So on the left there is, all the catch basins are connected together in series. You got 3 highlighted in red connected, chained together. That would not be allowed under the new manual. So the way that would be resolved under the new manual, you look at the right, you can connect 2 together, but then you have to go to a covered structure. Certifications, certification format and language that the department gets varies widely, which it makes review more difficult. So the intent here is to provide more consistency and have the applicants concentrate on what was really approved, right? Because a lot of times there are changes that are made to the drawings that aren't documented anywhere during the construction process. And this tries to avoid that and try to streamline that project closeout process. So a standardized format, clearly indicate what the expectations are up front, and then require that engineers identify deviations from approved plans. And there's lots of reasons why somebody would have to deviate from the plans. There could be an unforeseen condition, a utility in a way, that sort of thing. But those just need to be documented. And that is an overview of the manual. I'd be happy to answer any questions you might have.
Thank you. I'll go down the line. Start with Amy.
Implementation. Project planning for a typical homeowner when they're talking to an architect and they're thinking about design and they think about expectations on stormwater management. It's a long process. How do we account for all of these people that have been planning 2 years away from in the past, and now their projects are coming together and they've spent lots of money on consultants and architects and designers, and they've got to a point and now they're ready to apply, and oops, your standards have changed. How are we going to phase this in?
Yeah.
For that, because that's real.
No, understood, right. And hopefully, they engaged one of the engineers that was in those listening sessions, right, where we initially presented the manual, so they're aware of the changes that are coming. But there is going to be a gap between today and when the manual becomes effective.
Right. We talked about that.
Right.
Joe and I just talked before the meeting in terms of normally with the zoning change, you kind of give a shorter time for an effective date. It could be that this piece of the regulation amendments gets a longer lead time, whether that goes into late July or early August for the people that are just finishing up their projects. Want to beat the deadline, get it in. So if you have 700 square feet of impervious surface, you can get that application in the next month or two. And then
I'm thinking more about the person who bought a piece of land, they're tearing down a house, they've designed a new house, they've designed the Coltex and the stormwater, retention systems with certain standards and holding, and then all of a sudden they have to say, you now need to do a whole new analysis, and now you need to design a whole new storm system, and P.S. it may or may not fit based on the house that you already have, and you're hundreds of thousands of dollars in debt with architects and construction drawings. That's what I'm talking about.
Right. Yeah.
How do we account for that for these homeowners?
Understood, right? If they're following, they should also be following the state manual, right? Whichever is more stringent is, typically the guidance. So a lot of this is already in the state manual, but for those, people that have already embarked on, their design, they're not quite ready to submit. I think, Jeremy, that's maybe something we could discuss. Maybe, I don't know if we delay the implementation of this, or do we allow, some sort of
grace period or some
Right.
transition period. I don't know how you account for it.
Yeah.
I'm just raising it as
If the
potential
applicant
concern.
can demonstrate, for example, they did test pits on a certain date. That might be
Ah, okay.
a way to do it.
Oh, so if they've done these test pits and they've done this, okay, that makes sense.
Right.
So then that's the line in the sand. Okay,
Right.
that makes sense.
Just as a question, right? Because no matter what, you always run into that problem. So we could
Yeah.
postpone it for 3 months, and then somebody would come and say, well, you postponed it for 3 months, why not 3 months and 2 weeks? And then somebody's like, well, you did it 3 months and 2, why not 4? So there's always going to be somebody that's going to have done some work that unfortunately may have to change it. If, in your opinion, from what you've experienced as sort of the town's peer reviewer, would you say the majority of or if you could articulate, what do you think would be the number of people you've seen or reviewed in the last year or two that would have to make significant modifications and not just, okay, the Coltech's got to be increased by 10%.
Right.
Oh, we need to put a manhole cover instead of looping 3 and a daisy chaining 3 in a row. Would you say almost every one of the applications we've previously seen would have to be re-engineered, or would you say that most of them already conform to this new standard?
I would say within the past year or two, right, we're pretty consistent on what we ask the applicants. A lot of this, with respect to, for example, the sump pumps, right, because that's an issue at EPC. We've been asking applicants for that. And so, most of them, I would say 90% of the time, make some sort of provision for that.
Okay.
All right, so that I think the basement is probably the biggest one.
Yep.
I would say I haven't seen anybody take the freeboard for a pool in about a year.
Okay.
Right, so I think a lot of these are things that the consultants are already doing.
Right, so we're more
Applicants are
just
already
bringing the standards up to what we're almost informally already doing.
Right.
As opposed to saying, here are some onerous new regulations that now you have to comply to, sorry.
Right, right, yeah, exactly, right, yeah. So a lot of it, the consultants are already doing. Like
It's
this, like for
best
example.
practices.
Right,
They're
exactly.
already
Like
kind of
the precipitation is a great example. Right, the old manual said you can go back to the 1970s and use those precipitation totals, but just about everybody. In fact, I could say everybody within the past 2 years is using those updated totals. Right, and it makes sense too, right? From their perspective, right? You're, just because the volume of rain has increased, you also want your design to be able to perform.
Okay. Mike?
I'm good.
That's good. Going down the line, George?
Just to be clear, for the record, the manual will be referenced in our zoning regulations as, look at the manual, this has the force of regulations. Is that how that works?
Yes, what we're going to do is make reference to the new 2025 Stormwater Management and Drainage Manual. And on page 5 of the memo we wrote, we made it clear that it's the 2025 manual, which, and as we noted, may be amended from time to time. Just so you know, Joe gave this presentation to the Board of Selectmen in May, I think.
I believe so. Or was it April 7th?
April, May. So they're aware of this as well, and they asked some very good questions in terms of the impacts to members of the community, et cetera. And again, this is technically a DPW document that we'll be referring to. So Ed and Darren and DPW are comfortable with it. And I think you also presented this to the Sewer Commission,
Yes, we do.
brought it to their attention as well.
Wow.
Yes.
Good, okay. And just again, for the record, and maybe I should address this to Mr. Netter, but you referred to deviations that may be made. Is there any remedy by the Zoning Board of Appeals for those deviations, or would they all be reviewed by us here?
Right. Yeah, well, there are different types of deviations. A lot of them do fall to, I hate to say it, they fall to Ed here at DPW, because a lot of them are technical in nature. With respect to deviations as a whole, with respect to the regulations, I think that's when the ZBA would get involved. Jeremy, I don't know if you...
Yeah, I think, Joe, if I remember, right now we talk about lower third of the watershed.
Mhm.
You don't have to hold back water.
Right.
That will still be in effect.
Right.
That policy where the Planning and Zoning Commission could say, due to your location within the watershed, hey, I'm right on Holly Pond, why should I hold back my water? I'm getting it all the way coming downhill. There were a couple provisions where the commission can waive the
Right.
requirement for stormwater management.
Right, and then there's also situations, where the DPW director at his discretion could require the analysis of a 100-year storm, right? The town standard's of 50. We also added, certain situations where the analysis of a 100-year storm would be required, right? Right now, it's a 50-year, and that really applies to large development projects, where you have acres of impervious coverage, or, something like a Holmes or a Henley School.
Thanks.
George, to answer your question, it'd be really hard to get a variance for a drainage issue.
I imagine.
Because it'd have to be unique to the property, it'd have to be a one-off situation, it would probably not.
Yeah, but they could apply.
They could apply, but I don't think it would be granted.
Yeah.
Woody would like that.
No questions, thank you.
Okay. Do we want to wait till let's wait till the end for general public, because we've got
So
a
that
number
is
of
the
these. But I
first-
think, yeah, that's the
first
first chunk.
issue.
Thank you, Joe.
Thank
Sure.
you.
Now we're going to jump
Uh,
back to, how do you want to do it?
Now,
Jeremy?
actually, one last question for Joe.
Sure.
Joe, the commission's going to need to find that the amendments are consistent with the 2016 Town Plan of Conservation and Development, which talks a lot about low-impact development.
Yes.
A lot of mentions of that, and that would be consistent with.
That is correct. One of the standards, we have stormwater management standards, and the first standard actually refers to low-impact development, which encourages infiltration to the extent that you can get it.
That's
Because
possible.
being Darien, you might not always
Be able
be
to.
able to achieve it.
We have two more straightforward requests. Number 4 is to modify a number of sections of the regulations which change the reference from town plan or town plan of development to be town plan of conservation and development. I was doing a little research on the state statutes earlier on when did the legislature change that phraseology, and that was back in 1995, where they had a public act to change the name of the plan of development to the plan of conservation and development. So you'll see in the zoning regulations, a number of times where it's referred to a plan of development or town plan, and this series of changes will allow it to be consistent throughout the zoning regulations.
Just standardizing text.
Standardized wording,
Text.
which makes sense.
I assume nobody on the commission has any questions about that? Pretty straightforward?
No.
Okay.
We did like a keyword search for that, though?
I-
Right? We got them all?
I tried to get them all, but
Let's get them all.
there were a number of sections.
Okay.
And then proposal 3 talks about modifying section 873, which is a section of the Sediment and Erosion Control Regulations, to specifically refer to a new State of Connecticut DEEP document, which came out a few years ago. It's what Joe and the other engineers use, but we figured while we're updating some names and titles and documents, best to incorporate that while we're at it, if you will. So let's talk a little bit about items 1 and 2, which deal with smoke shops, vape shops, and tattoo parlors. I want to note for the record that, as with any zoning regulation amendment put forth by the commission, these had to be published in the Darien Times 2 times. It was also an article in the Darien Patch, and the town posted notice of this hearing on Instagram recently. The proposal was forwarded to City of Norwalk, Town of New Canaan, City of Stamford, and Darien Town Clerks back in April. As with any regulation amendment, we have to also refer it to a number of folks for comment, including the Western Connecticut Council of Governments. They sent in their comments, which technically I have to read aloud. Their comments were received May 20th. Good morning, thank you for submitting the attached referral for Westcott comment. The opinion of regional staff is that the proposal is of local interest and with minimal intermunicipal impact. Therefore, it is not being forwarded to adjacent municipalities, and regional staff is making no comment. We also sent it to the State of Connecticut Department of Energy and Environmental Protection. We received their comments dated June 3rd, 2025. Hi all, no comments from our office for this proposal. It is consistent with the Connecticut Coastal Management Act. You also received, for the record, comments from Chief Marin of the Darien Police Department, which you haven't received, and Mindy Chambrelli, the Darien Health Director. So we'll talk a little bit about these changes. The commission noted its desire to prohibit smoke shops, vape shops, and tattoo parlors, which one could argue have never been allowed in the town of Darien. But what we wanted to do is make it as clear as possible. So in order to do that, we had to define what those uses are. And so what we did was do a little research and found some definitions that we were comfortable using. You'll note that for the definition of tattoo parlor, there's a very specific exclusion for medical or cosmetic procedures performed by licensed medical professionals or certified cosmetic technicians such as microblading, permanent makeup, or paramedical pigmentation, which are becoming, I guess, more commonplace, if you will. We also had definitions of smoke shop, vape shop, and vaporizer, which is a word used in the definition of vape shop. You may recall back in 2024, the Planning and Zoning Commission specifically prohibited cannabis establishments in town, and this is very much in that vein to do the same thing here, to make it very clear from the regulations. I will note that in the explanation for the prohibition of smoke shop, vape shop, and tattoo parlors, Town Council wanted to make it, tweak the language I put forth, and I'll read the one sentence that changed for the explanation and justification. The Town of Darien Planning and Zoning Commission, which has never permitted such uses, find that they create risk to and adversely impact public health, and that this amendment will address those risks and adverse impacts. So they wanted to make it clear that the commission has the right to regulate public health and safety, and Town Council wanted to make that clearer in their comments. So what we've done is had a hearing tonight. I've mentioned the comments we received, again, from Westcog, Deep, Darien Police, and Darien Health Director. Open it up to any questions or comments from the commission or the general public.
I'd just like to note the comments from the chief of police was favorable for the banning or the change regulation banning this, as was the comments provided by the Department of Health. So they were all in alignment, to say the least. So anyway, I'll start down. Amy, do you have anything specific?
I have nothing specific. I'm very much in support of this.
Mike?
I think Jeremy answered my question, which was town council reviewed this and has signed off on this.
Yes.
My only question would be, why do we need to explicitly say cannabis? Is that because CBD is somewhat regulated differently than why doesn't that already fall under the cannabis prohibition?
Right, I think you're referencing the definition of smoke shop,
Yeah.
which is a retail establishment where 20% or more of the retail area is dedicated to the sale of tobacco and related products containing tobacco, nicotine, cannabis, parentheses, THC, CBD, flavorings, including e-cigarettes and paraphernalia, and/or includes areas for the consumption of smokable products.
Like they already can't sell that, so why include it in the language? Just for extra purpose? Or just for reiteration?
That's a good question. I could see either argument.
Yeah, okay. I'm just curious, because
That's a good question.
I'm not sure, but I could see maybe the state thinks cannabis and CBD are different, right?
I can answer that for you.
So, okay. All right, that'd be it. George?
So, I had an instinctive reaction, which I wanted to stick with, which was that I don't like banning a line of business as a broad matter. I think I said that when we had the needle guy here one time, and just as a matter of principle, if they think there's a market here, and if they're permitted by the state, and if we regulate them properly and the Department of Health does their business, I don't see why we should stop them before they even make an application. And I have heard it said today that we have not permitted them in the past. That doesn't mean we banned them in the past. They were permitted to apply. I am persuaded by the letter from the Chief of Police and the Director of Health that a vape shop is not appropriate, or a vape shop or a smoke shop is not appropriate for us. I confess to being surprised when the chief included a reference to the vape shops and how sexual assaults have been investigated as a result of some sales like that. So, and minors have been able to get THC apparently through them and whatnot. That's not a bag of issues that I have any interest in our taking on in this town. I don't think that's appropriate, and I do not wish to get into an argument with the Chief of Police. He's got very good knowledge and resources, so I'm fine with that. I would, however, say that a tattoo parlor is a different thing entirely, and I would permit someone to apply to create a tattoo salon or a studio or whatever they may be able to call it. I do not assume that we will suddenly be getting an influx of bikers or gang members or anything of that sort. I think we probably all know people that, it may surprise us, have tattoos. And they are considered an art form. And it apparently takes real talent to be able to create that kind of artwork. I am not suggesting anybody do it to their bodies. That doesn't strike me as a good idea, but it happens. And there's a market out there for it. And I don't see why we shouldn't let someone apply to us for an appropriate space and under appropriate regulations to do that kind of work. So I would exclude tattoo shops, parlors, salons, whatever, from the prohibition that we are discussing here today. I just think that I have to say it also has smacked of an elitist attitude that I don't like. As a native of this town, a lot of us are natives of this town, and we're all sensitive to it. We know what this town is about, how it has changed, of course. And I suppose it'll always be a somewhat elite town, but I don't like us as a governmental body saying that, no, we're above tattoo parlors. We can't have that sort of thing here. I don't like that attitude at all. So I would ultimately move to strike that language from the proposal.
Thank you.
Thank you.
I believe the health director felt that it was going to be burdensome to enforce the regulations required around tattoo parlors. There was I believe in the letter. So I am in support of keeping that in. But I am curious how we came up with the 20%, or how our town attorney did.
You know, it's interesting, Jamie, when we did research on how do other towns handle this. So, for example, if you think of businesses that sell cigarettes or cigars or other things, it might be a very small piece of what they sell. So I think there's a Darien cigar shop that sells newspapers, magazines, Coca-Cola, Pepsi-Cola, Band-Aids, aspirin, and maybe some cigars or whatever. So there was a number in terms of how much of something can they sell that you'd be like, oh, well, that's such a minor thing. It's not a shop, and we've all seen them or driven by them in Stamford or Norwalk, where the whole shop is just vaping, smoke shop, whatever it is. So the question is, could you do a shop where it's less than 20% where they sell tobacco products? And so I looked at that definition. I said, well, maybe that might be the right number. It's not a magic number. It's not set in stone. But after reading, I'm like, well, maybe that seems logical for someone who might be in town now that sells cigarettes. Their whole business might not be cigarettes. might be a small part of our business. So it's a good question. I'm glad you asked it. So it's you're on the record in terms of what is that?
In terms of
appropriate number?
enforcement, how would we ask them for schematics of the floor design and to where they're about to put these? Because let's say I work in Midtown Manhattan, every single bodega you go into has a short order cook grill station, place to buy lottos and candy, right?
Yep.
And then in the back has just cabinets full of paraphernalia and a bunch of smoke stuff, which would be close to 20%, maybe some more, some less, depending on the size. But how do you say you're at 19.5 instead of 21.2, right? So how do we enforce that?
Yeah, that's going to have to be something that we get into as people apply
For
for
a special
certain types of
permit.
uses that,
Okay.
now, we just had one that a gentleman that wants to come in for a convenience store.
Right,
So we would say, oh, okay, you're going to have to lay out for us,
what you're doing
you know,
where.
this is the refrigeration space, this is the freezer space, this is the counter, and kind of lay it out such that we can make an affirmative finding that it complies.
And there's nowhere in town that an establishment like this could operate as of right. It would always be under a special permit that would be for us anyway, right?
I wouldn't necessarily say that's the case.
You know where?
Retail sales and service in the central business district and several other commercial zoning districts in town.
Could have it.
Could have it as of right.
Right.
It's not to say that it wouldn't allow for zoning review.
Right,
you
so
know,
they would still have
you know,
zoning review.
Internal to the planning and zoning office. But as far as the commission seeing, reviewing, and acting on an application for commercial sales and service, it wouldn't necessarily be the case.
And for the, let's say the cigar shop in your example, I think you're thinking of maybe Darien Convenience on Tokenique Road? Is
yeah.
that what you were thinking of? Would they be grandfathered in? Like, let's say he's at 21%. I don't know what I haven't been in there in 2 years, but for whatever reason, let's say it's at 25%. Would they be grandfathered in, or would they then have to get figure it out, come back, bring themselves up to code? How would that work?
I think we'd have to go take a look, and certainly if they're under, we would certainly write them a letter. Hey, we see you're selling products which may qualify you as a smoke shop. However, you don't reach the 20% threshold, so you're good, but just so they would have to come on record that they're aware of.
On notice, yeah.
And we don't have any data about, let's say, like a gas station convenience store, right? It's like that sells,
Cigarettes.
cigarettes and stuff. What percentage of floor space that is? Because I could see 20% being kind of high, right? I could see you allocating a lot more space than I think this regulation would be comfortable with at 15%. Versus, if we say, if the goal is to allow quick service restaurants to sell basically cigarettes, like a gas station quick serve or like a newspaper type of place, that's going to be like under 5%, right? They're not going to allocate a huge amount of space to some wall of cigarettes of 30 different brands from everywhere under the sun. So if that's the case, the 20% number to me almost sounds on the higher end of it than what we would generally want. If the goal is to, because you could run a lot of loopholes into trying to get around that number. What if you would take into account the back storage, right? The back, all these places have some storage area in the back. Does that count as part of the retail space? You look at the square footage of a 2,000 square foot place, and you got, 400 square feet of smoke stuff there, and you're under it.
Right.
That's a lot.
Right, and if you think of a gas station convenience stores, some of them are very small, maybe the size of this table.
Yeah.
And others are very large, 2,000, 3,000 square feet.
Right.
So they do vary greatly.
Inside.
Some sell everything under the sun, and others just sell, in the old days it was newspapers, but now it's, maybe it's just, as you said,
Yeah,
So-
I'm somewhat, I don't know.
so maybe the 20% number might be too high.
Right, because
maybe 10% is
it's
more
a letter of the law kind of thing. We see it all the time in other applications where you're allowed X number of whatever, and you do half an inch less than X, and that's it. And you're like, well, it's pretty tight. People will try and get around that if they think it's a use. Okay. Anybody else?
I agree with the percentage being too
Yeah,
high.
it's a little too high, right? Okay. Well, since this is a public hearing, I would like to open this up to the public. Would anyone from the public like to speak? Just, sure, sir, come on up, just say your name, affiliation, and then go from there. You want to plug it in over there?
Yeah.
Welcome.
Thank you.
We've seen you before, but for the record,
Better to be seen than viewed,
indeed.
which is part of this presentation, right? Maybe you're not looking for square footage, maybe you're looking for percentage of sales, because the square footage might not mean a whole lot. Maybe it's a matter of percentage of sales overall in an establishment that might qualify it as a smoke shop or other.
There you go.
Okay, well, again, thank you, and for those of you I don't have the pleasure of knowing, I'm Mark Sticka.
Wait, hold on a sec. Karen, can you hear him?
I can't,
I think
yes.
You have to be at the
I have to
thing
be
for
there?
TV
Okay.
79 to pick you up. Sorry, sir.
All right.
I know what you're trying to do, trust me.
Sure. For those of you I don't have the pleasure of knowing, I'm Mark Sticka. I am a resident here in Darien. I'm a retired captain from the Connecticut State Police, former commander of the statewide narcotics task force. Currently a member in retirement of the National Alliance of State Drug Enforcement Agencies. Just returned from a conference earlier this last month, May, in St. Augustine, Florida, which gave me some insight into this. But what really brought this together was seeing this notice in the patch 2 days after I went to a New York, New Jersey HIDA, and HIDA stands for High Intensity Drug Trafficking Area, conference hosted by 908 Devices regarding fentanyl overdose investigations. It was an 8-hour training. Almost an hour to an hour and a half of it dealt entirely with vaping, because vaping is one of the mediums that especially children are utilizing for the consumption of illicit drugs, especially marijuana, THC, and fentanyl. It is a gateway to that, and there is no question about that. I'm currently an adjunct faculty member at the University of Bridgeport, teaching criminal justice. I've attended Westfield State College, Virginia, University of Virginia, Columbia College. The question is, why prohibit these things? They're inherently dangerous. That's pretty easily stated. But what is vaping? What is it all about is probably a good place to start. They both, smoking and vaping, involve heating substances, and you'll hear me refer to combustible cigarettes and electronic cigarettes, or CCs and ECs, throughout the presentation here. Traditional cigarettes, you inhale the smoke that comes from the cigarettes. With electronic cigarettes, you are inhaling a vapor that is created by an electronic or a battery-operated device that heats up a liquid that then turns into vapor that you inhale. The difference is there's still adverse effects on the lungs, but the vaping delivery system is much like a nebulizer. I'm currently suffering from some allergies right now, but I refuse to take drugs unless I absolutely have to. I do have an inhaler for sports-induced asthma. Never been on a nebulizer, but a nebulizer works a little bit different than an inhaler, right? Because you are getting a vapor that comes up. The nebulizer, when used pharmaceutically, turns liquid medicine into a mist. Patients inhale it. It gets into the lungs. If it's being effective, it's supposed to open up the bronchioles so you're able to breathe better, right? Chemicals used in vaping are far different than those that are used pharmaceutically for legitimate purposes. Instead of bathing the lung tissues with a therapeutic mist, like a nebulizer, this coats the bronchial passages with a liquid that just hardens and doesn't evaporate. The chemicals that are in there are pretty scary when we get down to it. Well, the delivery device is supposed to be for either nicotine and the traditional for cigarettes, right, as a replacement, or in the most nefarious delta-9 THC. And you want to know the difference between CBD, THC, marijuana, what have you. Marijuana is a plant-based substance that contains approximately 100 cannabinoids or cathinoids that are in part psychotropic, especially the delta-9 THC. CBD is an isolated cannabinoid that has been proven effective in some studies to deal with some chronic illnesses, right? Still, the efficacy of those things are still out there. Why the government continues to pass these things through as legitimate medical, I'm not sure, because I've never heard of an actual doctor prescribing these for medical purposes, right? But the THC, the delta-9 THC, is a psychotropic that causes the psychological effects. The CBD would be a receptor that would block certain nerve reaction, and we've seen this in epilepsy with children, right? That's the #1 use for CBD, and it's been shown to be effective in reducing the effects of epilepsy in children. But what chemicals are you inhaling? You're inhaling some sort of a carrier, if you will, that will bring that substance to you. Most of it is vitamin E. Vitamin E, when taken orally, is fine. Vitamin E, when taken inhaled or vaporized as it is, hardens right in the lungs. The other additives that are there are diacetyl, formaldehyde, alkaline. You can see them listed up there. Not real good things for your lungs, and we'll see why. This vaping has increased ADHD in children. These studies have come from the National Institute of Health, the Center for Disease Control, Johns Hopkins University, the Food and Drug Administration. That's where all of my sources are coming from. What I want to focus on is EVALI, electronic cigarette and vaping associated acute lung injury. That is what is troubling about this phenomenon in use. This use, when we look at it, not only through adults but through the children, through our surveys, have you ever used an e-cigarette or electronic vaping product? Just one time, some days, every days, we see an increase. We were seeing a stark increase up until 2019, and then something happened in 2020 that caused everyone to kind of stop vaping and all these other things, but now they're now back on the rise because of these electronic nicotine delivery systems, whether they're e-cigarettes, vape pens, cartridges or carts, or makeshift pipes, or the most nefarious, where the youth have graduated because of the addiction that they're now going to fentanyl and now inhaling vapor from cooked fentanyl pills or chasing the dragon. You'll see that on the tin foil and the lines on the tin foil from people heating up the pills and inhaling that vapor. It's the same concept. Lung-associated problems with EVALI is shortness of breath, fever, cough, vomiting, diarrhea, headache, dizziness, rapid heart rate, and chest pain. It has been responsible for acute respiratory distress syndrome, hypersensitivity pneumonitis, and BO, bronchial obliterus, more commonly known as popcorn lung. What's popcorn lung? It really got its name from something that the FDA figured out back in the 60s and 70s, that a food additive, diacetyl, which was listed before, was used in popcorn to simulate butter flavoring. In the factories, these factory workers were getting sick, popcorn lung, from inhaling this, coughing, wheezing, chest pain, shortness of breath, and then long-term effects afterwards. There's now vaping-related pneumonia that's specific to the vaping, chronic cough, shortness of breath, coughing up blood, bludged in mucus. Not a real good treatment for it, other than supportive care while the lungs heal on their own, if they heal on their own. And then probably the worst one, a primary spontaneous pneumothorax, or a collapsed lung, happens when the vaping is so much and the tolerance is not there. Sometimes this is over time, sometimes this is immediate. With the national youth trends, these battery-powered devices, and I don't think inhaling batteries is good for anybody to start with, right? But that's really what's happening. They, in addition to the battery coil and everything else that is in there, again, the psychoactive substances, the carrier substances are particularly harmful to lungs. Why are youths doing this? Taste and entertainment, experimentation, and to replace combustible cigarettes. When you look at these numbers compared to what is going on in Europe, compared to what is going on in other parts of the world, folks in other parts of the world are utilizing e-cigarettes to try and get off of smoking. Our youth are looking at it for taste and entertainment, experimentation, because it's specifically marketed towards them. And there is no question that it's specifically marketed towards them. I spoke of this last year when we were talking about keeping the cannabis shops out of here. The cannabis shops, the cannabis industry is owned by Big Tobacco. It's just another way to get them in there. With these particular products are associated with the Communist Party of China. And with the border now being closed, there is an uptick in these being smuggled in here, and specifically not through China because they don't want to break trade agreements that are there, but we're now seeing a great influx from Southeast Asia like India and Pakistan that is directly tied to Indian and Pakistani organized crime that's on the international level. So again, vehicle for substance, again, with these youths, they are also vaping other substances, most notably marijuana. Middle schoolers, 40 to 50% of middle schoolers have tried THC through vaping. That's scary. That's middle schoolers, right? Carts, vapes, wax pens. Because of that, it's more dangerous. It's a more concentrated delivery system, and the concentrations of the THC, the psychoactive ingredient within those marijuana concoctions, is up to 90% pure. It becomes highly problematic, in some cases addictive, certainly has psychological effects, which is why the second most abused drug by youth right now is Xanax, to counteract the effects of the marijuana. That Xanax is not necessarily just diversion, it's also by designer. They are specifically marketing fake Xanax that's out there. The next one that comes into play with this, this pathway is fentanyl, either by M30s, and I'm sure you've all seen M30 pills that are out there, the blue pills with the M30 on them. How can you tell the difference between a real M30 and a fentanyl M30? It's very simple. They're all illegal. They're all illicit now because the company, Mallinckrodt, was sued. They are now out of business. They're not making the M30s anymore. So who's making the M30s? The drug cartels, the folks that are assembling them, whether it's China, India, Mexico, or wherever these are coming from. They are also going to powder lacing and chasing, as we spoke about, and one of the easiest ways to do this is through the availability of vapes and the vaping devices. Tobacco our advertising targets youth. We've known that since Joe Camel, right? But the fake, not the fake tobacco, this e-tobacco product accessibility, it's specifically designed to go after youth with flavors, social influences. The adolescent brain sensitivity to nicotine is higher than that of adults. 68% of youths that have utilized this product have utilized a product that has specifically had the words ice or iced within the product line because it's designed to make them think of something cool, make them think of something like iced tea or iced coffee or what have you, when in fact there's really no ice part of it. Students have used the e-cigarettes, 87% use flavored. If it's not marketed towards kids, I'm not sure what is. What does this look like? Is this for adults or is this for kids? So national trends for adults, because we're going to continue on this. This becomes highly addictive like cigarettes. Sometimes it's one and the same with nicotine and the THC. We've had an uptick in mental illness, in suicide, ADHD. Nicotine adversely affects the brain development in animal models and increases the risk of further substance abuse. It's definitely a gateway. Secondhand emissions is safe. We knew that wasn't the case with cigarettes. There's nothing to doubt that the same isn't the same for vapors, especially because of that effect of coming up, coming down. Again, the nicotine, the ultrafine particles, the other chemicals that are found within this is harmful to those around. Folks are going to be walking out of these shops, lighting up, puffing out, and we're walking through it in downtown Darien. Right? But again, the vape stats, high schoolers trying it is now up to 40 or 50%. Vaping illnesses have been on the uptick. There's a story about a 16-year-old track star kid. Vaped for about 3 months, underwent a double lung transplant. Right? That's what a double lung transplant looks like in a 17-year-old. There is a criminal element to this as well. We know we have to go no farther than one town east to see high-profile, major problems with vape shops because of the criminal element that is hiding in plain sight there. Utilizing THC products like gummies, psychedelic mushrooms. It goes on, and I highlight this case. This was the last case that I was in command of, a Title III wiretap operation that started with a small buy of fentanyl and led to the products that you see there. One of the things we saw back in 2019 was the sale of marijuana vape cartridges, empty cartridges just being sold, presumably to place whatever adulterated drug in there to be sold out there. Along with that comes firearms, ammunition, bulletproof vests, unsavory characters. The final thing that I leave you with is this. I have a place in North Carolina that I go back and forth in frequent, so I see a lot of what's going on down there. There's a phenomenon that hasn't quite hit up here yet, but it will be coming, and it's called gas station heroin. Does anyone know what gas station heroin is? It's a drug called tianeptine. It is a plant-based drug, so it's very hard to regulate, what have you. It has been used in some studies to try and combat the effects of depression. But what it has, it works very similar to heroin in terms of, or any opiate, in terms of how it affects the receptors in your body to ease that pain. It becomes highly addictive, it becomes highly reliant. It's not regulated right now, so it's not illegal in a lot of places, but the moniker gas station heroin kind of lends to what you all are talking about in a gas station, with how much a percentage of my business is going to be e-cigarettes or vapes or whatever the case may be. I don't know if it's a footage or if it's a matter of product. A product like that, coupled with these other products hiding in plain sight, it doesn't take 20% of a footprint. It only takes a small amount, along with illicit back room and cookbooks and otherwise, to utilize this. This is why we've had these high-profile vape shop busts right next door in Norwalk over the last year. I'm open for any questions or concerns that anyone have. I commend you on the work that you're doing of keeping this place safe, but this is really about the kids when you get down to it, because it is targeted towards the kids.
Great. Thanks.
Thank you
Thank
very
you.
much.
I appreciate your time.
Would anyone else from the general public like to speak to any of the proposed regulation changes that we've put forth? Anyone else? Okay, seeing none. Well, we have to deliberate these.
Right.
Do we want to leave this open, or do we want to close it?
One option would be to close the hearing on all these items,
Yep.
deliberate at an upcoming meeting, talk about issues that have come up tonight, questions that you've all brought up, and then see how it shakes out. What we talked about earlier is there may be some of these proposals that are more urgent to get an effective date, and it could be we have an effective date, different effective date for each of these, whereas the stormwater regulations, we want to give people more lead time. Maybe the vape shop, smoke shop ban is a little more urgent, and so we can certainly,
But we can't close 2 of the 5 items. It's all or nothing for the closure. We can deliberate on them.
We can close and deliberate, and we can.
Yeah, change them,
We can
change up.
change effective dates
Yeah.
during that
Yeah.
process.
Like that.
So-
Okay, so let's do that. I don't think there's anything more we need to keep the hearing open, right? So do I have a motion to close the, Jamie makes a motion?
Actually,
Oh, sorry.
Before we close it, do we have his presentation in the record, other than what was presented here tonight? Do we have
I can certainly ask, Mark, can you email it to the
Since
commission?
he-
That way
Since
we'll
he gave
upload
it, it's
Right.
part of it, but I think if we
Right.
upload it to the
That'd be
record,
helpful. You have my email, right?
Yes.
we
Great.
can
Thank
tack
you.
that in because we've seen it.
And maybe some testimony about gas station heroin, is that what it was called?
Would that be part of the record that,
Yeah, then he testified.
Yeah,
yeah,
but I mean,
and
just,
the minutes?
yeah, just maybe an email or something to upload to the website.
That'd be great. That'll become part of the record. Thanks, Mike.
Okay.
Sorry.
Motion to close the application. Jamie makes a motion. Amy makes a second. All those in favor?
Hearing's
5-0. Hearing is closed. Okay, moving along to the second and final item on the public hearing. This is a land filling and regrading application number 587 TL 2565 Sabino Iacovone, I'm sorry, I have a bad last name too. Jessica Bacigalupi? Not bad? I'm a Balgash, so, you know, give me a hand. 3 Dogwood Lane North. Proposal to construct a new addition to an existing family residence, construction of retaining walls, perform related site development activities, including regrading of the property to accommodate the improvements, and installation of stormwater management. The 1.1 plus or minus acre subject property is located on the southern terminus of Dogwood Lane North, approximately 170 feet west of its intersection with Arrowhead Way, and is shown on Assessor's map number 64 as lot 27 in the R1 zone. Jeremy, what do we got?
Fred.
Fred, what are we doing here?
So this application was submitted in conformance with section 850 of the Darien Zoning Regulations under land filling and regrading regulations. The application was referred out to Joe Canis of Ty and Bond. He submitted comments for the record dated May 27th. Those comments were responded to by the applicant on May 28th in a written narrative and revised plans submitted in response to those comments. And Mr. Canis submitted comments, follow-up comments on the application this afternoon, today, June 3rd, requiring some additional information and clarifications from the applicant on a number of issues. Mr. Canis is here this evening to address the commission and cover some of the additional information that he feels is necessary from the applicant. The application was also referred out to the building department. The building official, Mike Beatty, submitted an email for the record dated May 8th noting no issue with the application. It was also referred out to the Darien Health Department. The Director of Health, Mindy Chambrelli, submitted an email for the record dated May 17th noting that a septic review would be required as part of the process. And we also note that we did receive one neighbor comment on the application from 1 Dogwood Lane, the abutting downhill neighbor from the subject property. And this evening we have the property owner here, Jessica, accompanied by her engineer, Wayne Devanzo, to present some of the details of the application and answer any questions you have.
Thank you. Welcome. Just state your name and affiliation for the record.
Yes, Jessica Bacigalupi. My husband Sabino Iacovone and I own 3 Dogwood Lane.
Welcome.
And you covered all the basics, so they're in the record. I think based on the new information that we got today, there's some outstanding questions, and we can address as many of those as possible as we can here, and then confer back with Wayne on what else needs to be updated to meet the new queries.
Okay. So how do we want to do this? Do we want to have Joe come up and talk about I only briefly read it since we got it in today, but there's a number of outstanding issues that have to be revised. There's stuff that has to be added to the surveys.
Correct.
So I don't think it's this normal stuff, adding an extra silt fence that we can kind of address as conditions of approval either way.
Correct.
So we can go through those as much as possible, or we can leave it open and continue it until next week when those are all updated, and then just take one big stab at it, right? Because we're gonna have to come in and essentially just re-review anything we do tonight.
Yeah, I mean, because we have Joe here this evening, I think the best next step for the commission would be to at least briefly hear from Joe on some of these outstanding items that are here that we need to deal with, and then I think you're right. It makes sense for the commission likely to continue the hearing, either to depending on what the applicant is able to do in response to those comments and how quickly they're able to turn that around. The commission could continue the hearing to as early as next week, June 10th, and then the meeting after that would be June 24th. The meeting of June 24th is quite full at this point, so if the applicant is able to quickly turn this around, and Joe is in a position to be able to review that response, I think we can fit it in on the 10th, but I think
And then
There's a lot of ifs.
it is a lot of ifs.
Well, we'll hear from Joe, and then I'll let anybody in the public speak to this if there's people here. This way they don't have to come back and provide the exact testimony in a week or two, since they've already sat through an hour of regulation changes.
Let me just blur it out, if I may, with all due respect, Mr. Chairman. Mr. Candace has had a productive night tonight, I think, and I don't worry about if he, has killed another half hour by being here for this. There's a lot of stuff. I don't need to know what he needs to know. All I want to know is how's that all been resolved. And if we can't know that tonight, I don't find it a productive use of time. At the same time, I'm worried about the public. If they are here and they want to be heard, then maybe that would inform what else has to be done, but
Okay. I'm okay with that. I think everybody else is.
If I may, just for a moment. Wayne
Sure.
Devanzo, Fairfield County Engineering, engineer for the applicant. Actually, some of these comments are not relevant. I think there was a revised plan, excuse me, there was a revised plan that Joe hasn't seen yet, so it makes some of these comments moot. The rest of them, I do believe we could address fairly easily. We actually did soil testing there just this morning. It was the major reason we didn't have a retention system for the footing drain, so we can now do that. We did, through the soil testing, we did determine that indeed the addition is going to be in ledge largely. We found ledge 14 inches deep, so the addition will be in ledge, so groundwater isn't going to be so much of an issue. Nevertheless, we will do and are now able to do and design a retention system for just the retention, which was the biggest item in my opinion here. The rest of these are fairly, we can address simply with the yard drains and some of the other issues. So I think it's.
Yeah, but I don't think we can close the hearing without the updated documents.
I understood.
So either way, we're going to be back doing this.
I mean, my opinion is we see a lot of these, and we see, when I see this many comments from Joe.
Yeah, there's more than one.
There's a lot that we're gonna need to digest.
Yeah.
So I tend to be in George's camp, where I want to be appreciative of everybody's time that came out tonight, but at the same time, for us to dig into the information and have appropriate questions and opinions based on the information we hear. I don't think I'm in a position to do that
Yeah, I agree.
today.
Okay.
I'm sorry.
So it looks like, well,
But that's just my opinion. That's just my opinion.
yeah, that's what I'm exactly. So, Joe, you get a break tonight from all the hard work. I'll wait for them to submit the changes online, and then you can review it, and hopefully we can get this on the book pretty quickly, since, it is pretty close to being done. I agree. I think there is just enough to merit a second, instead of being able to close it. It's not 1 or 2, but I don't think it's 2-hour hearing type situation. So I think we could probably hopefully bang it out next week, maybe?
I think so.
Okay. So that being said, I'd like to open this up to the general public, since I know some of you may or may not want to speak here. I should note, as staff mentioned, we did receive one letter from the neighbor at 1 Dogwood Lane. So I just want to make sure everyone on the commission sees that. That included pictures with some rainwater and some puddling on the side yard, and some concerns over drainage. Just to state that before anybody else, that's already in the record. So anybody from the general public who'd like to speak to this application, please, I invite you to come up, say your name and address, and any comments you have regarding this application.
Sure.
Welcome.
Hi, how are you?
Hey.
Daniel Ibrahimi, 16 Arrowhead Way.
16, okay.
So just to give you a frame of reference, we live on a downward slope from...
You're down the hill, right?
That's right.
Yep.
So we currently have our own water issue in terms of flash flooding, storm management. So we're trying to resolve that with the town and get approval. So we've had a lot of back and forth, I believe with Joe and our engineer. So my outsized concern is, I'm happy for everyone to do, whatever they want to do with their property and house. But I just don't want it to exacerbate our issue, especially since we haven't resolved it yet. And the septic is at the rear of the property, and we're on a downward slope.
And you've got that river that goes to the
optically,
front of your property, right?
It doesn't. I'm sorry?
You have the trench drain that runs to the front of your property on Arrowhead?
That's right, and we're trying to get approval to have, some of that water funnel through, since that is a dry trench,
Yep.
that dry creek. And it's slow, but, I know that's the process.
Yeah, okay. Yeah, we
Yeah.
appreciate that. Certainly, the goal of the drainage analysis and the retention systems is to make it, at least not make it worse. Make it some way
Right.
to improve it.
And we have wetlands on the property, we have a lot of mottling,
Yeah,
with the
there's a
soil.
pretty big
So
elevation
there are
change.
limitations with
Yeah.
infiltration systems and things like that. You can't just put it anywhere. We've just had another soil test, which, kind of rules out certain areas.
Yeah, I understand that. Okay, thank you.
Okay.
Yeah, we'll absolutely take that into consideration. Hello,
Hi.
welcome.
Hi, thank you. Sumi Ibrahimi, 16 Arrowhead Way as well.
Okay.
And just to reiterate what he said, the topographically,
Yeah.
we are on a significant slope.
Big slope, yep.
So directly where their house is, anything would come down. And you may have noticed on the plans, there's a significant amount of ledge right there.
Mhm.
And the septic tank is also bordering our property. So we have a lot of issues, and we don't want to exacerbate our own problems that we're trying to alleviate as well. And from what I saw, it looks like it's a significant amount of square footage. That's, whether it's on ledge or not, I don't know what kind of issues that's going to cause, and I don't know that anyone could guarantee us that it's not going to cause flooding on our property. And especially over the last few years, it's gotten worse. I think it's gotten worse everywhere, right? So I just worry about it. I have allergies. I'm severely allergic to mold. So if we do end up having, we haven't had issues, but if we do end up having flooding and the house has issues, I could be in severe, I could have severe health issues. So that's it. Thank you.
Thank you for your time. Anyone else from the general public like to speak to this? Sir, welcome.
Good evening. You have our comments. I'm Sean Olson from 1 Dogwood Lane.
Thank you.
My wife Leslie is here with me tonight. So you have our comments, our photos. I read, we asked for a peer review, and I believe that that is in progress, if not already done, so we appreciate that. I read the comments on the way here tonight and understand that there are a lot of questions that are yet to be answered, so we're looking forward to hearing what those answers are. And again, as we stated in our message, we fully support our neighbors and their project. We just want to make sure that any work that's being done doesn't exacerbate the problem that we're having, which, as you guys saw in the photos, was a significant amount of stormwater runoff that floods our yard. So that's it. We appreciate the time.
Yeah, great. Thank you. Thank you for coming. And yeah, we have the photos. We've got the letter you submitted. So it's already on the online packet. Thank you. Okay. Would anybody else in the general public like to speak to this application? No. Okay. Seeing none. So date for continuation next week.
Yeah. So this application will be continued to June 10th at 7 p.m. It's going to be a virtual meeting via Zoom, which will be noticed later this week on Thursday afternoon. We'll be circulating the details for that meeting.
Okay, great. All right, with that is the end of the public hearing, and we will now move into the general meeting portion of the evening. I'll take a moment if anybody would like to leave after having sat through our proposed regulation change discussion.
You and I agreed. It's like when lightning's going to strike, or?
It's scary.
Okay. All right, so moving on to the general meeting. The first item on the agenda is the proposed attached ADU of Janet and Jonathan Resino of 80 West Avenue, also known as ADU 25-4. And this is an ADU that's coming before us, not because my understanding is it's not a new ADU, but that it's just a change in the designation of the home to go from multi to single with an ADU. Is that correct? What do we got here?
That's correct. There's a few moving parts here, but the property is a little over a half an acre, 0.58 acres in the R1/2 residential zone on West Avenue. It is an existing two-family non-conforming property that predates zoning. And the applicant is looking to essentially convert that two-family house back to a single-family home with an accessory dwelling unit. And that second unit already exists. It's about 645 square feet within the larger single, we'll call it footprint of about 4,800 square feet.
46.
The assessor's records, as far as I see, list the total square footage at 4,879 square feet.
Okay.
So the commission is, of course, seeing this evening because the ADU is less than an acre. It's on a property less than an acre. So it's in front of you for your review and action tonight. They've submitted all required information in connection with the application as far as the ADU checklist, the assessor's card, the floor plans for the accessory dwelling unit, and that has all been confirmed with our department in terms of the maximum square footage of 700 square feet for an attached unit, being no more than 30% of the principal structure plus the ADU. We also note that there are about 6 parking spaces on the site, 2 within an attached garage area, and then 2 separate parking areas, which
that was going to be my question, because it looked like through all the calculations that it was fine, but I didn't see the ADU checklist on the online portal. Do we normally?
Yeah, I don't either see that yet.
Like it's usually part of it, and that's the one thing so I went through. I believe It's not on there.
Yeah, we'll have to double check on that. You know, I can pass it down to you if you'd like to see it.
No, I just think it's a lot easier than, we got the letter, we've got the as-built survey, we've got the architectural diagrams of the first, second, and third floor, but that's it.
Okay, we'll have to double check on that. And
But we can add that.
We'll go ahead and upload
Yeah.
that to the application.
That's fine. I believe it
I thought
conforms
it
to
was there.
all of the checklist items, so I don't think
Mhm.
it's a problem. I just want to highlight it's not there.
Yeah, okay, thank you.
No worries.
The property owners are here tonight if you have any additional questions for them.
I don't have any additional questions for you, but I'll ask the members of the commission. I'll start with Amy. Any questions for you? This is a pretty straightforward application. Mr. Nutter?
I'm not going to belabor it, that's fine.
Okay. Mr.
No,
Riley?
No problem.
Yeah, nothing. Okay, nothing. So we don't need to do anything. Do a straw poll or?
My real question is, why are we doing this? But that's okay.
Because it's part of our regulations that we see that things under an acre, just to
No,
make
but
sure.
It's grandfathered.
No.
No, it's multifamily grandfather.
What is
The ADU isn't.
Yeah.
It was just in front of ZBA.
Right.
Rejection went,
What they realized, which is the case, is they had a non-conforming two-family. So every time they wanted to do an expansion, they had to go to ZBA to expand.
That's a Woody rule. I don't agree with that, but okay. I'm going to stop talking.
So, in this case,
These poor people have gone through enough. Let's approve this thing.
Okay. Do a straw poll to approve. All those in favor?
5-0.
You got your ADU.
Thank you.
You're welcome.
you.
Have a great night. Sorry for making
Thanks
you
for-
wait that long.
Thanks
Thanks
for
for your
waiting.
patience.
Thank you for your patience. Get home safe. Okay, let's deliberate on the first thing since it's a pretty straightforward. So I'll just read it into the record. This is the coastal site plan review 371A, flood damage prevention application 433A, land filling and regrading application 588, PL 2536, Charles and Kristin Collier at 65 Pear Tree Point Road. This is the proposal to construct retaining walls and landscaping steps and to perform related site development activities within a regulated area, including minor regrading activities to accommodate the improvements. This is the hearing that we heard, I believe it was last week,
Last week.
with the upgraded stone walls that need to be dug out and then re-poured, basically down on Pear Tree Point Road. It was a pretty straightforward application. They're not going to use that curb cut that's kind of close. They're going to use the further one away, and then they're going to be gentle about it. I don't think it'll be a major impact to traffic. They said they didn't anticipate it being a very long build either when the architect or the engineer was here. So I thought it was very straightforward. I don't know if anybody else has anything outstanding they want to talk about with it. Amy?
No, I was fine with it.
Yep.
Yep.
Mike, you watch on TV?
Yeah, I was just knowing for the record, I watched it on TV.
Anything to add?
Nope.
Nope. George?
Packets, right?
I'm good.
Jamie?
Yes.
Nope?
all good?
Okay. So I will instruct staff to write up a approval for the new retaining walls.
Do we have it?
Oh, we have it? Oh.
Yeah, you got this in your packets.
There we go. To end decision. That's right. Thought we had the other one. I didn't see anything in this one that was anything other than straightforward. Right?
Correct.
Yep.
I didn't see any typos or Scrivener's errors.
Well, if you didn't, then there aren't any.
All right. I entertain a motion to approve. Mike makes a motion. George makes a second. 5-0.
5-0, as written, thank you.
As written.
I have the draft.
Okay, now, where we get into the
Deliberations only.
deliberations only on the following amendments to the zoning regulations. COZR 1/2025 put forth by Old Kings Highway North, number 104 LLC, and Old Kings Highway North 108 LLC, PL 2579. Proposal to amend section 766 of the Darien Zoning Regulations to increase the maximum floor area of dwelling units within the designated DB zone from 1,000 square feet to 1,250 square feet, and to allow developments on smaller lots less than 20,000 square feet within the DB zone and have up to, bless you, 8 two-bedroom units with no single-bedroom units. Bless you. Proposal to amend section 766 of the regulations to reduce the rear yard building setback for developments complying with the inclusionary zoning regulations, section 580, from 25 feet to 10 feet, where certain findings are made by the commission. Proposal to amend section 906 of the regulations to reduce parking setbacks for developments from 10 feet to 0 feet, where certain findings are made by the commission. Proposal to amend section 945 of the regulations to reduce or eliminate perimeter landscape requirements, where certain conditions and findings are made by the commission. So this is a zoning change for the two buildings over by Trader Joe's. It's kind of a unique lots when you merge the two, which is why they're asking for the decrease from 25 to 10 and the parking setbacks from 10 to 0 to accommodate the pad basically in the back where the garbage is or would like to go. It is a change to the regulations for, you know, a specific space, but it doesn't, the changes don't give any new rights of development. So the commission, it allows the commission to waive requirements if findings are made. So we're not simply allowing these setbacks to decrease. So there is some flexibility on an application by application basis to do it. So overall, I'm not the biggest fan of doing this, but I understand this DB zone is probably a zone in town that is going to see more development from residential units as opposed to commercial units. And this is a good use for the space with what they're planning on doing. So I didn't have anything in particular that I saw, you know, how they wanted the changes to the regulations to be made seemed okay with me, just because it allows us to waive them, but doesn't give a future applicant the ability to waive them. It was consistent with the POCD as it was written. I think there were some pages highlighted in that. And yeah, so I'll open it up to comments. Amy, what do you got? What are you feeling?
Yeah, I for some reason I can't find my notes, but what struck me was the three together. Like, I didn't love the fact that I know, my apologies, I can't find my notes. The reduction of the setback, the parking all the way up, and then I forget what the third one was that you just cited.
It's the 1,000 to 1,250 with no single bedrooms.
And then there was also landscaping.
The landscaping.
Yeah.
Yeah.
It was the three together that I was like, and I specifically wanted to know what else would qualify out there that somebody else could potentially come forward.
We did ask them that. He didn't have a list. I don't know if staff checked that out. I thought that was nice of what they did over at Thorndale when Sherry Klein said, okay, we want to change the setback on 95. Here's the 3 other properties in all of your town that could potentially be affected by this, and they were kind of, okay, that was a nice thing to have.
And you could just say,
I don't think it's a nice thing, I think it's a requirement.
Like, that should be,
You need to have that.
yeah. With this one, I just was like, those are 3 levers that when you put them all together, it would be horrible for a homeowner that abuts a property to have all of those things.
Yeah.
In this particular case, with everybody that abuts, it's okay. In my mind, it's reasonable, but.
What else?
And I don't love the certain conditions and findings language. I'm just not sure what exactly that is.
And that was my point, is that
there's no standard there.
If the next application where this comes up, we're all still here, we all can be like, oh yeah, remember, but well, what are the odds that the rationale continues forward and that a future commission understands this? So I personally really would like to see what else this could affect.
You mentioned them merging the lots together. That wasn't clear to me from the presentation either. Are they merging these lots?
They are merging the lots, yes.
Okay, because they've got them under 2 separate owners.
Correct.
As 2 separate LLCs, and they've pledged to merge them into one lot.
That was my understanding.
I'd make that if we were going to.
It would have to be a requirement, 'cause then setbacks and all that, so.
Yeah.
But I agree with you. I think there's unintended consequences to approving something like this without knowing what other parcels it applies to.
Yeah.
And what certain conditions and findings are. I mean, that's just such a nebulous standard to me. That could be anything.
Yeah.
Yeah.
And so because
Go
of
either way,
that,
too.
I would like to see.
It could cut either way, you're right.
Yeah.
I'm not disagreeing. I'd just like to see the inventory that we would be sort of putting the
Putting at
standard
risk.
to.
Yeah.
Yeah, yeah, so that's, those three together and not knowing where this could impact, I'm kind of at a, I don't mind the site development and the corridor that it's in, and it makes sense. What else are we using that for? There's other condos right along that corridor. It kind of makes sense there. I'm in agreement for that, but I do need the zoning change or that we need to dig a little deeper on.
And they scaled it back dramatically.
Yes.
This was originally 16 units, and they cut it in half. I mean, they certainly listened to the EPC. I'm just worried about where this applies and what other parcels this applies to. That's really my biggest concern.
Yeah.
Not necessarily applying it here, but what are we doing overall?
Yeah.
Yeah, staff can certainly do some research on what else would
Get
potentially.
a copy of the zoning map.
Yeah.
Yep.
Just highlight it.
That would be
I
very
mean,
helpful.
I don't think we're we're definitely not going to close this tonight just because the chairman isn't here, and I think he should weigh in on proposed zoning change.
Yep.
Versus somebody doing a renovation on their home, for example.
Yeah.
So we're definitely not closing it today, but yeah, I would like, and I think it's a good idea when you're discussing this with future applicants on zoning changes. They're going to want to see a list of everywhere in town, so you guys don't have to do it, right?
Yeah.
I don't know if
I think that's
it's a good thing, but I think Jay Klein might have accidentally given you more work for this specific application.
Yeah, Wilder,
Sorry.
Wilder Gleason, yeah.
Yeah, we can certainly,
Well, Jay was by the one who did it first, by
Right.
saying, explicitly outlining it, and we all went, well, that was really
Yeah.
smart, now we know exactly where it'll apply,
Yeah.
now we're gonna ask that on every question.
I think it actually started with Parklands.
I think it did.
Yeah, you're right.
Yeah. So, George, anything you got on here?
Well, I guess first, I'm not sure why Mr. Netter has that concern about just the notice provision, when in fact the language of the amendment is more specific about what the conditions would be that we would need to determine, like the loading
The
zone is
findings,
screened
yeah.
by a minimum 6 fence and there's no adverse impact to any nearby residential use. Now, so that I think is more specific than what the notice provides. At the same time, that does raise the question of the word nearby, which we discussed last time, and they also said, I forget what their alternative to that was, but I
think they
think,
wanted to change it from abutting to nearby to make it more
Oh,
flexible
okay,
for more
maybe
people
so.
to challenge it.
And maybe we apply the same standards that where we notice whether it's 100 feet.
that's exactly what I was
Yeah.
thinking.
Yeah.
Whoever gets notice of the zoning,
Qualifies as
Yeah.
nearby.
yeah,
Yeah.
And should it be just residential is my question, because commercial property. could
yeah,
be,
that's fair, that's fair, yeah,
Impacted as well.
Yeah.
right,
So I think you got a
Absolutely.
couple
Yeah, I mean,
things
it
to
could
worry
be
about.
a
yeah.
small doctor's office in a giant apartment complex, and the
Yeah.
dumpster goes in right
Yep.
next to you with no
With
screening.
Right.
You can see that's not necessarily
Yeah.
helping the business.
Yeah.
Yeah.
Mhm.
Okay.
Good point.
I agree with the other points that were made.
Okay, so we will keep this for
Keep this moving
a
along.
future day,
Okay.
and we'll let staff.
Right, this
Yeah,
is
to work
something
on
that
it.
we can continue the deliberations on next week as well.
How long do we have?
65 days from the close of the hearing, so you have March, or May to June, June to July. Keep in mind, the hearing on the site plan is still open, that's
Yep.
been continued to June.
Yeah,
So-
that's not closed,
Correct,
that's been continued.
June 24th.
Yeah,
Oh,
So,
right.
so you still have time.
With time on that, on that one.
And it could be that during the continuation of the hearing, more things come to light.
Yeah. Okay. All right. Deliberations on anything we heard tonight, so we didn't, I think the first one, let's just punt the deliberations unless we want to deliberate the first one.
Yeah, when we did the agenda, we had thought that 3 Dogwood might close tonight, so, I mean, it's up to you if you want to deliberate on the
first one?
on the first one or not.
You're all waiting for Steve.
Yeah, that's what I was thinking,
Yeah.
waiting
Okay.
for Steve. I mean,
Yeah.
I think
He's gonna
I think 3 out of the 5 of them are super straightforward, and we don't need to talk about them. I think it's the other 2 that are the meat and potatoes of it. I don't think changing the text from the plan to the planner, you know, I'm surprised that we even need to do that, and you can't just do it as a clerical update, but I understand. So yeah, so we'll wait for Steve, we'll deliberate that next week.
Deliberate next week, okay?
Okay, chairman's report, I don't have anything. Director's report, Jeremy?
No, the only thing to mention, which we were talking about a little bit before the meeting, is the housing bill.
Yep.
From what Fred tells me, was signed by the
Passed.
governor.
Governor signed it.
So we await the details and the effective date of certain provisions, which could necessitate some very quick zoning regulation amendments over the next few months. If things take effect October 1st, and we need to change regulations, that needs to be done pretty quickly. So we wait, like everyone else, to see what the ramifications are, and inevitably, whatever passes this year will have to be cleaned up or corrected next year, because it was run through so quickly
Yeah,
that
it's so
there's
big, it's
no
so
human
quick.
way to
Yeah.
figure out everything.
You don't anticipate anything like an opt-in that might have to go before the RTM and the selectmen?
I have
You know,
not
'cause that-
heard, I've not
Or
heard
an
from
opt-out,
everyone.
you know, because
Let me sell you a house, and in 3 months, I'll just tell you which one it is and how much you have to pay.
Exactly.
So we'll find out more details over the next couple weeks.
But lawyers are good at lawyering. That's what they get paid to do. They love reading big, long documents, right, guys?
Fred, did you circulate the bill that was passed?
I haven't
The Senate
seen.
changed it slightly,
Yeah,
so it got marked up a little bit.
So there was the main bill and then a couple revisions to the bill, and then I haven't seen a single bill with all the revisions incorporated into it, so I will
But
try.
then it's been signed.
Governor probably hasn't either.
I'm sure it's,
No,
I'm sure it's
Yeah,
there.
it was mentioned
So-
in the
Controversial Appendix A.
Appendix A?
Yeah, there was an Appendix A that was blank. You just basically said we'll fill it in later.
It's like the appropriation.
Details.
And the appropriations.
This is
went in.
insane.
No.
This is insane.
Great. Okay,
And they had through tomorrow night.
good.
I don't mind putting in a plug for the Connecticut Mirror, if any of you are
Yeah, they've had
familiar with it.
surprisingly good reporting on this one.
Yeah, they have a very good article today summarizing. They generally are very straight down the middle.
There'll be quite a bit of informational sessions and training coming out in the coming days and weeks on this bill. So for anyone that's interested in sort of hopping on to one of those, or wanting to know more about it and how this is gonna not only affect Darien but the state as a whole, we'll keep you all up to date on that as well.
Yeah, definitely send those along. Okay. Upcoming meetings, next week, 24th?
Next week, June 10th, as Fred mentioned, that's a virtual meeting. Neil from H&H will be talking about the final survey results, if you will, the final document. You heard a presentation last week. He's also going to give you the summary of the meetings he had with various groups, boards, commissions, departments, whatever. I took a quick look at that, so that should be ready as well. He'll summarize that. He's also going to talk about what he's hoping to have in early July, which is public outreach session, probably in the Mather Center. Probably we're aiming for July 8th or 9th at this point. So that'll be the main event. We're also going to have the continuation of the public hearing on 3 Dogwood Lane North. And I think, Fred, we had deliberations on,
Yeah, they're.
Darien Diner wants to do a small bump out. So it's a minor site plan approval.
Okay.
So it should be not crazy long. That's why we're able to do it virtually. And as Fred mentioned earlier, 6 or 7 public hearings on June 24th. It'll be a lengthy night, but we're optimistic that they will all be fairly routine.
Buttoned up.
Yeah, I
Meeting the
don't
17th.
think
No meeting the 17th.
any of the agenda items really for June 24th are going to be too much of a lift for the commission, or too controversial.
Okay. And we don't want to have a 17th meeting? To mix
Opting
it
for
up.
more meetings?
Too late now.
Opting for.
Well, it's like we could do 2 hours, or we could do 1 4 hour.
I think this is a 3-hour meeting.
Okay.
I'm out of town the 17th.
I have a work event.
Okay, so 17th is out anyway. All right, never mind.
Yeah.
Okay then, and then,
Hope to hear the 24th.
any other business? No. Do I have a motion to adjourn? Mike makes a motion, Amy makes a second. All those in favor? 5-0.
That
8:46.
was Rob.
Oh, no. Getting sensitive now? Don't.
No.
Can't.